Hello my viewers at home and welcome to my YouTube channel Daily Express. Please do well to hit the subscribe button and subscribe to my channel. Also, the Federal Capital Territory FCT in Nigeria is subject to unique land management regulations under the Federal Capital Territory Act, FCT Act, and the Urban and Regional Planning Act. These laws empower the Minister of the FCT, the Federal Capital Development Authority (FCDA), and the Department of Development Control to regulate land use and enforce urban planning policies. However, these powers are subject to strict procedural requirements, especially when the demolition of properties is involved. This write-up briefly examines the legal framework for property demolition in the FCT, focusing on the requirement for notice and due process, as well as relevant and most recent judicial pronouncements. Section 18 of the FCT Act vests the ownership of all lands within the FCT in the Minister of the FCT, who holds the said land in trust for the benefit of the people. This statutory provision grants the Minister broad powers to manage and control land use, including the authority to approve or revoke allocations and enforce compliance with development standards. The exercise of these powers must align with constitutional guarantees, including the right to property under Section 44 of the 1999 Constitution as amended and statutory safeguards provided under the Urban and Regional Planning Acts. Section 47 to 60 of the Urban and Regional Planning Act provide detailed procedures for addressing unauthorized development, which may culminate in property demolition. The key requirements include issuance of notice before any demolition action. The relevant authority must issue satisfactory written notice to the property owner or occupier. The notice should specify the alleged contravention, e.g., unauthorized developments or failure to comply with planning laws, and provide a reasonable period for compliance, such as removing the structure or regularizing the development. Right to respond. The affected party must be given an opportunity to respond to the allegations, seek clarification, or present evidence of compliance with applicable regulations. Hearing and review. The law emphasizes the need for transparency and fairness in enforcement decisions. Where the property owner contests the notice, the matter may be reviewed or resolved through administrative or judicial mechanisms before any enforcement action. The law also provides for urban and regional planning tribunal that can review and hear the matter. Demolition order. Demolition should only be carried out as a last resort and must be based on a valid demolition order issued by the relevant authority. The order must comply with statutory provisions and be executed within the bounds of the law. In the very recent case of Isiaka Musa versus Minister of the Federal Capital Territory and 2RDERED, the procedural safeguards enshrined in the law were put to the rest. In the very recent case of Isiaka Musa versus Minister of FCT and 2RDERED, the procedural safeguards enshrined in the law were put to the test. The case involved the demolition of properties in the FCT by the Minister of the FCT and the FCDA without due notice to the affected persons. as litigating counsel for the claimants in the matter. I successfully argued in the address that demolition violated the procedural requirements of the Urban and Regional Planning Act and the constitutional rights of my clients. The court on the 22nd day of January 2025, upon consideration of the evidence, found that the affected persons were not given adequate notice or an opportunity to respond before the demolition. The demolition was carried out in contravention of the statutory and constitutional safeguards. Consequently, the court awarded 10 million naira in damages against the Minister of the FCT and the FCDA for their failure to follow due process. The judgment in Isiaka Musa versus Minister of the FCT reinforces the principle that public authorities, include the Minister of FCT, must strictly adhere to the law when exercising their powers. It emphasizes that the ownership and management of land by the FCT do not negate the right of property owners to due process. Issuance of proper notice and adherence to statutory procedures are mandatory requirements for any enforcement action, including demolition. Failure to follow these procedures exposes the authorities to legal liability and damages. While the Minister of the FCT, the FCDA, and the Department of Development Control have the authority to regulate land use and enforce planning laws, this power is not absolute. Procedural safeguards such as adequate notice and the opportunity to respond to notices or queries are essential to ensure fairness and prevent the arbitrary exercise of power. The case serves as a critical reminder that the rule of law must prevail even in matters of public administration and urban development. Hello my viewers at home, what's your reaction to this as FCT High Court ordered the Honorable Minister of FCT, FCDA and AMMC to pay 10 million naira for wrongful demolition in Abuja. Please drop your reaction in the comment section. Ensure you subscribe to our channel and share this report across all news platforms. Okay, right here we have some reactions here, but time is never a friend. Ensure you subscribe to our channel. Bye for now. Do join us in the other news. Okay, thanks so much for listening. Bye for now. Okay.